Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I'm Thomas Vick, joined by Seth Wilson. Seth, how are you today?
Thomas, I'm doing great. It is, getting close to championship game weekend and the Final Four. So I'm looking forward to some basketball and maybe catching up on a few things over the weekend here. How about yourself?
I couldn't agree with you more. I'm an Indiana University basketball fan, so our season hasn't been all that great, but it was great to see Indiana State in the NIT championship last night. Watched that. Unfortunately, they weren't able to pull it out, but on good news, my alma mater, Freed-Hardeman University, won the NAIA national tournament last week, which was a huge deal for everybody in Henderson, Tennessee, small town of West Tennessee. So, uh, you know, great time for basketball, and I really enjoyed this season of the year.
Yeah, it's a lot of fun. It's reminiscent of what you do where you're working so hard for that outcome, and then you have a chance to put that all together at the end of the season, whether that's the NIT with, like you say, Indiana State, or whether that's the NCAA tournament, or my son is up at Trine University and they won the D3
That's
national title
right.
this year.
That's
So
right.
it's all of these crazy things. That happen in March. I guess that's why they call it what they call it, which we won't say on the air since I guess it's trademarked and all that fun stuff. So,
Yeah, it's been a
well,
great time.
speaking of kind of putting these things together and getting them ready for the audience to see, so to speak, you have introduced a new program I wanted to make sure folks were aware of as part of your law practice. And I'm sure this will go out in the blog digests and things that are there and probably already has, but I thought it'd be good for us to kind of talk through the program, what it is about and what it's for. So if you would just kind of walk us through what is the Vick Law Medicaid Plus program.
Yeah, well, I appreciate the opportunity to talk about that, Seth. So the Medicaid Plus program is designed to allow the law firm to kind of walk beside clients as they're navigating long-term care and Medicaid eligibility after Medicaid eligibility has been obtained. Medicaid is a month-to-month eligibility kind of program, and it's reviewed every year. So after an individual has gotten on Medicaid, there are annual redeterminations 12 months after they've gotten eligibility. And if income isn't where it's supposed to be and resources are not where they're supposed to be, that annual redetermination process can really trip Medicaid recipients up, and they can lose their Medicaid status. And unfortunately, with the unwinding post-pandemic of the public health emergency, there have been a lot of people that have been tripped up that I've noticed in my law practice. And so I wanted to design a program that uh, can allow the law firm to stay there with the client and navigate some hurdles that are presented by annual redeterminations and other notices that people get from Indiana Family and Social Services Administration. Um, Indiana Family and Indiana Family and Social Services Administration has their hands full because during the pandemic, nobody went off of Medicaid. So, usually you're supposed to be kicked off of Medicaid if you have resources, for instance, over $2,000. But that wasn't happening during the pandemic. People just kept on Medicaid. And right now we're in the middle of the process of unwinding that pandemic rule under the national health emergency. And because FSSA has their hands full, they're issuing notices that are not really making a whole lot of sense. For instance, just this week, I had a notice that says that the individual has been approved through an auto renewal process, and the annual redetermination will happen 12 months from now. And then the next day I got a notice, and it was dated the same day. The mailing date was the same day, but it said that benefits are going to be terminated come next month. And so, and I talked to the nursing home administrator about that for this particular client, and and the administrator said, yeah, I've been getting these kind of notices as well. And so there's a lot of kind of confusion that's happening right now. And to address that, and just generally, without the pandemic at play, people have questions about what's happening with their loved one's Medicaid eligibility. So I thought we need to design a program that will allow individuals to continue to keep us in contact with them and communicate with them and talk to FSSA if necessary for an affordable price. And, I'm charging $75 a month for this Medicaid Plus program, sort of to give an allotted amount of time from the law office for any questions that might come up, and then to give a discounted rate on any hourly fee. So that's sort of the design of the program, and I think it'll be helpful to individuals that participate.
Yeah, it sounds like it will really help reduce kind of the barrier to picking up the phone and, well, maybe I can figure this out on my own. And yes, this is happening, but then 2 or 3 days goes by between the receipt of the letter, which is going to get closer to that benefit reduction or termination date and those kind of things. So this sounds like a really great system for the clients who are in that scenario, to give them really some additional peace of mind that they have a lifeline, if you will, and a resource available to them, and can kind of keep that available whenever those questions arise or when those notices get received.
Yeah, and usually I do Medicaid applications and getting individuals on Medicaid for a flat fee, so that people know exactly what they're getting into. But it's a larger fee, and so you don't really want to be billing clients, with large flat fees each time that they, uh, call the office or what have you, and you have to do something with FSSA. It's the idea of, what you're getting into with this program, and what the cost is going to be, and how much the law office can help you. And my experience is that, it's really a matter of just talking to FSSA when there's a mistake that's been made, and the problem can be solved fairly quickly. But, people are busy. People don't really have the time to wait, 30 minutes on hold with FSSA. So with our office staff and with me, we can be on hold and talk to FSSA for the Medicaid recipients. So that's the program, and I think it'll be beneficial to folks. Appreciate you letting me talk about that.
Yeah, well, I think it's such a service to those who really need that ongoing support as they walk through that process. And the approach is great in terms of, I think, how you're approaching it, and it's priced to be very affordable and accessible to folks who are in that scenario. And I think that's a big help, because otherwise you wouldn't be able to provide that service and keep the lights on your world as well. So appreciate you doing that for folks who need it. I think that'll be a good thing. And it kind of, you mentioned being busy and walking through that. A lot of times we find that individuals who are in this Medicaid scenario are kind of in that, what we call the sandwich generation, right? And so you may be managing a loved one's care, and they're a little bit older, but potentially you haven't gotten everything set up for yourself. And so that kind of, you had a blog post that went out this week, or last week I think it was, that talks about the 3 times or 3 signs where you definitely need a trust versus a will. And that kind of caught my attention, kind of thinking about those two worlds, because that frame of mind when you're helping mom or dad or a loved one through that Medicaid process, kind of, well, how can I do some planning around that? So What are a couple of those signs or times that you need to get that trust in place versus just a will?
Yeah, well, the first one that's listed on the blog post is if you have a blended family. So I see this a lot of times where there are, children from husband and then children from another marriage with the wife, and maybe they're maybe the family all lived together, maybe they didn't, and if they didn't grow up together at all, I see if the kids didn't grow up together at all and they're basically strangers to one another, it can be an awkward situation to kind of navigate. And I think one of the best ways of doing that is to do a trust, and perhaps doing two different trusts. Maybe the husband has a trust of his own and the wife has a trust of her own, and then they can be beneficiaries of each other's trust. But then upon the passing of the surviving spouse, then that trust asset can go to the parents' own kids, rather than there being some kind of shared percentage among the descendants of both husband and wife. And so a trust is a great way of doing that, providing for the surviving spouse while also providing for the kids of your own biological children. That's one scenario. There are a couple, there are a whole multitude of ways that you can design trust for blended families. Sometimes they want everything to go equally among their own kids. And that's a great situation as well. But a trust is a great way of making sure that a person's intent is carried out.
Yeah. And it can be a little more challenging to try to do that through a will-based plan, because ultimately you are relying on a document that only comes into play after someone passes. And typically, if there is a transition to the surviving spouse, that surviving spouse has the right to change the documents and the plan after the first spouse to pass would occur. And so, if the intent was to make sure that everybody got something equally, and yet, wait a minute, I wanted to make sure that this, set of assets that I received from my family stayed in my family line before the second marriage. You've got to address those concerns a little bit. And it can be a little bit of a challenging conversation to try and figure that out, because sometimes I'll find I ask a question that somebody wasn't really thinking about an answer to, and you go, "Oh, wait a minute, we may need to stop here for a second and just talk through these issues and these considerations to make sure that you're ultimately putting that plan together that respects everyone's wishes in the scenario, especially on that blended family situation."
Yeah, and let me ask you this, Seth. How about providing for a place to live for the surviving spouse? What are some ways that you can provide for that within a trust?
Well, I like using what's called a right of occupancy trust, or language inside the trust that gives the surviving spouse the right to live in the house for his or her lifetime, and then decide what happens to the house at the expiration of that trust. And, I kind of describe it as almost like a lease agreement inside of your trust, in terms of what the rights are and who is responsible for ongoing mortgage payments or those kind of things. You know, if there's an insurance claim that needs to be made, who makes the determination as to what to do with the house? Is that the trust's responsibility or the trustee of the trust? Or is that the individual living in the house through this right of occupancy? And so that's a good way to address that and sort of hold that unit together, if you will, that family unit, secondary family unit that was created, and yet then preserve how the asset of that house is divided up later, whether that's, this one spouse brought the house into the marriage, and so those proceeds need to go minus that right of occupancy trust down to their lineage, or what have you.
Yeah, I think that right of occupancy trust is a great tool for clients. Sometimes people will do a life estate, for the surviving spouse, and that can work out okay, I suppose. But having a trustee that can manage what happens with that property as the surviving spouse ages and may need long-term care, it gives you more flexibility and control in that trustee's hands to make sure that the wishes of the grantor are carried out. So, yeah, I think that's a great way of doing it as well.
Yeah, lots of considerations there and lots of variables, and so that's why it's always helpful to sit down and kind of walk through that for your particular situation. But one of the other items that you list in these times, and I agree with this one kind of and recommend it wholeheartedly, is if you have real estate in multiple states, it can be a good idea to have that trust set up so you can avoid a situation where you may need probate in multiple jurisdictions. And one thing I always like to point out to folks, just because this is a scenario that I've faced more times in my career than I ever thought I would, was what happens if you have like an oil and gas lease interest? Is that real estate? And the answer is oftentimes yes.
Yes. Yep.
And so taking that into account, where you may have inherited something from a family member and you didn't even kind of really put two and two together, that interest that you inherited is actually a real estate issue. And so to transition that asset will require a personal representative to be appointed if you don't put that into trust. And so I know you and I have talked about this many times, but we kind of try to look at that total cost to the estate, and a trust can oftentimes be more economical because you're really just titling that asset into the trust during life, and you don't need a formal probate or ancillary probate proceeding in multiple jurisdictions.
That's exactly right. And think about the cost that is potentially there when you've got an oil and gas interest in some property in Texas, and then you've got a house in Indiana, and then you've got some savings in Indiana, and maybe even a condo somewhere or a timeshare somewhere outside of the state of Indiana. Those are just small things. We don't really think about those timeshares, but it's a real estate interest, and so that maybe that's something that can be put into a trust so that there's not a probate administration or some kind of probate proceedings that happen in another state. So, yeah, the cost savings is a big factor in recommending a trust. And then on that.
Well, I was going to just put a pin in that timeshare discussion, because that's a topic that we could probably talk about for a long time. There's a lot of things that go around and happen with a timeshare, but certainly if you have a timeshare, you're 100% correct that that's often a real estate interest, be it a very small interest or what have you. But it is it can be a little bit of a challenge to handle timeshares. So that's something definitely to talk with an estate planning lawyer about, if that's something that's in your collection of assets.
Yeah. And then the last one is privacy. And this is something that I've seen a little more often recently. Privacy is really important. And, when a person has a will only and that will is probated, that means that it is, on display, and it's going to be subject to scrutiny by the judge and also by anybody that might contest it within the time period to contest a will. And, that's kind of putting your will on display, and then all your, on the stage. I think I said this in the blog. You're putting the will on display on the stage, and then all your family are actors on the stage, and the whole world is watching what's happening. And that's a little bit dramatic, but it is setting it up to be a public forum for people to figure out what do they have in their will, who's getting their stuff in the will. And, that's really interesting when it's Michael Jackson and his estate, but not necessarily as entertaining when it's your own family that's going through that kind of thing. So if privacy is, important to an individual, having a trust is important as well.
Yeah. And I think the combination of that statement in your blog post was and avoiding probate, right? And that's, to me, that's one of the primary drivers I see a lot of times in my practice is I don't want to have anything to do with probate for the reasons you just explained, which are the public nature of the probate process. And if you have that requirement because you have a last will and testament without having those assets into trust, then that's what you've subjected the family to. And that may be a decision you're comfortable with. We're lawyers. We're not really concerned about going to court most of the time.
Yeah.
And we recognize that in most cases, probate's pretty straightforward and works out. But there are occasions that you kind of see the things that show up on the news, right? Where there's these administration fights that last for a long time, and you get to know all of the details that are there because it becomes public record, right? So yeah, so that's just that hand in glove fit on those two concerns, that privacy side and avoiding probate. And there's so much additional benefit that comes from avoiding probate that, to me, that always, if we're trying to balance the scale in favor of a trust or a will, that definitely goes on the trust side to point in favor of having a trust in place.
Yeah, definitely. I strongly encourage people go on the trust-based plan rather than the will-based plan for all the things that we've talked about. Privacy, if you own property in multiple states, a trust is a good idea. If you have a blended family, a trust is a good idea. And those are just 3 reasons. There are many, many more reasons why a trust would be a good option, but we don't have all the time in the world to go through those today. So we'll stop right there and end the discussion on trust at that point.
Well, appreciate the time as always, Thomas. How can people find you?
Yeah, the best way to reach me is by going to viclaw.org. You can book a call through the website, viclaw.org. How about you, Seth?
We are located here in the heart of Hamilton County in Noblesville, Indiana, and that's our web address, noblesvilleattorney.com. It's the best way to get a hold of us.
All right. Well, thanks, everybody. We'll talk to you next time.
See ya.